Thank you. I appreciate the introduction, and I thank Farida and other members of the team for the support in putting this paper together, which I will be presenting on behalf of the team. I should add that I am a member of the research team on this project, and that is the capacity in which I am presenting, and not necessarily in my capacity as an individual or necessarily in the capacity of UWA, but of course, as an employee of UWA, I got involved in that project on that basis. So it is important to add that I am presenting in my capacity as a member of the research team on the project. So my presentation is on unlocking economic potential, navigating legal frontiers for Africans in Australia. Can we go to the next slide? So the African population in Australia is growing, and whether people like it or they don't like it, it seems that the population is growing. And the presentation that was made earlier by Sarah Quick shows that Australia is hosting is the 12th largest African diaspora community. And as at the last census, there were about 496,000 Africans living in Australia. So the growing African population in Australia comes with opportunities and challenges in terms of Australia-Africa international economic relations. And in particular, it provides opportunity for the expansion of trade and investment between Australia and Africa. So this particular presentation seeks to look at the extent to which laws and regulations serve as opportunity for the growth of trade between Australia and Africa, or they serve as barriers. And that is part of addressing the main question, one of the main questions of the project, one which Farida just referred to, that we want to come up with research that addresses the negative aspect of media and other forms of presentation of Africans in Australia. And we want to see the extent to which the law serves as a barrier, serves as an opportunity for Africans who want to make meaningful contribution to the Australian economy. Can we go to the next slide? So in terms of theoretical analysis, and I'm sure I don't want to bore you with the literature on jurisprudence and what is law, what is not law. If you want to study the law, I'm sure you can join me at the Faculty of Law here or at Curtin University or any other university, and then we can go into the nitty-gritties of what law is and what law does not do. But I think that a study of the law and economic agency of Africans in Australia is important, because the law, as a rule, frames or regulates human conduct. So, for example, the law gives us or confers us with rights. Before we could enter, I could enter Australia, for example, I needed a certain permit called a visa. A visa gave me the right to be able to enter Australia and to be able to speak to you today. So in that sense, the law confers rights and protects individual rights. And in that sense, the law enables, it is a facilitator of individual agency. But the law also imposes obligations, duties, liabilities, and so forth. So again, the law will impose on you, tax on your income or tax on your purchase of goods and services. And in that sense, the law can also constrain what you want to do. So that to the extent that the law confers rights, it gives rights, to the extent that it regulates human conduct, it can enable and it can also constrain individual conduct. So we are interested in both aspects of the law to the extent to which it facilitates, the extent to which it facilitates or constrains the economic agency of Africans in Australia. Can we go to the next slide? So generally, when we look at Australian law, obviously, it gives individuals rights, it imposes duties on them, there are liabilities, and so forth in relation to cross-border trade between Australia and other countries, including between Australia and other African countries. But maybe I should give you the main point that I intend to make here, which should be the take-home point, that Australian domestic law and international economic treaties and covenants are both enabling and constraining of the economic agency of Africans in Australia. And I'll try to substantiate these points. But in terms of definition, when we make reference to economic agency, we are talking about the autonomy and freedom of individuals to be able to participate in the economy. For example, to be able to go for a job that you feel you are qualified to go for, to be able to set up a business and run it, and so forth. So these are examples of what we mean when we use economic agency. So I will try to substantiate the argument that the law is both enabling and constraining of the economic agency of Africans in Australia. Can we go to the next slide? So before I go into substantiating the main point that I seek to make in this presentation, let's look at the nature of trade between Australia and Africa. The figures that I had access to shows that Australian goods and services trade to and from Africa were valued at 9.6 billion in 2001. And these investments are largely concentrated in the extractive sector, the gold and other natural resources. And the concentration of investment and trade in these areas, the natural resource sector, raises the question whether or not there is a need to expand the trade between Australia and Africa, given the growing population of the Africans in Australia. And I will argue that there is a need to expand because trade in these sectors, the natural resource sector, for the most part, benefits the large companies and perhaps the government. Individuals hardly benefit from that. So there's a need to expand trade and investment between Australia and African countries in a manner that serves the needs of the Australian economy, the African economy, the growing African population in Australia. All right, let's go to the next slide. So now, in subsequent sections of the presentation, I will be looking at law and economic agency, and I will be looking at international economic treaties that Australia is a party to, and their role in promoting or impeding economic agency of Africans in Australia. Then I will shift to look at domestic law in Australia and economic agency of Africans in Australia. So the first section will look at international economic treaties. And by international economic treaties, I am referring to free trade agreements that Australia has concluded with various countries. I'm also looking at bilateral investment treaties that Australia has concluded with and their implications for trade and investment. And generally, free trade agreements, bilateral investment treaties are concluded essentially to promote trade between the countries that have signed to these international economic treaties. So when I make reference to international economic treaties, I am referring to bilateral investment treaties. I am referring to international trade agreements. And free trade agreements contribute to economic activity by reducing and eliminating tariffs. And the reduction of tariffs, the removal of tariffs, essentially make it possible for businesses to engage in cross-border trade and investment. So generally, international economic treaties can be enabling of the economic agency of Africans in Australia. In terms of the international economic treaties that Australia has concluded, Australia has about 18 free trade agreements that are currently in force, that have legal force. And none of them is actually concluded with an African country. There are also 15 bilateral investment treaties, which are concluded, Australia has concluded with other countries, which are currently in force. And there's only one of them that has been concluded with an African country, which is Egypt. Australia has 40 double taxation agreements with 40 different jurisdictions. And there is only one of them that has been concluded with an African country. So as you can see, there is limited international economic treaties between Australia and African countries. And the point that I will be making at the end of the day is that the limited international economic treaties between Australia and African countries means that there is limited international legal rights and protections available for Africans interested in doing business in Australia or even doing business back home. Can we go to the next slide? So basically, these international economic treaties are intended to provide for various rights, what foreign investors can do, traders can do, in relation to tariffs, in relation to undertaking foreign investment with limited restrictions from the host country. So I am saying that Africans in Australia have the opportunity to take advantage of the limited international economic treaties. Those who are from countries with which Australia has concluded these treaties to carry on investment and trade in Australia, and at the same time do trade and investment in their home countries. Can we go to the next slide? So, and as I said, Australia has only not a single free trade agreement with an African country. There is only one double taxation treaty with South Africa. There is only one bilateral investment treaty with Egypt. So if these treaties are important for promoting trade and investment, then their absence will show that there is no scope for international legal protection of Australians in Africa who intend to do business in Australia and also back home. And the absence of a double taxation agreement, for example, means that if you are an African and you are here and you choose to do business here and you choose to do business back home in your home country, then you are going to be subject to taxation of your business activities, both in Australia and in the home country. And large taxes can actually impose a lot of burden on the growth of businesses. So the limited international economic legal protection for Africans, there is limited international economic protection for Africans in Australia. And that is largely because of the very limited trade and investment between Australia and Africa. Okay, can we go to the next slide? So what does the conclusion of a double taxation agreement mean for example, facilitating trade, facilitating investment? So double taxation, the role of double taxation agreement is to help to avoid double taxation and prevent fiscal evasion, which essentially means that if you are running businesses or you are present in different jurisdictions undertaking economic activity, then you don't get taxed by both jurisdictions. Now, because Australia and South Africa have a double taxation treaty, the implication is that South Africans who choose to do business here and engage in other forms of economic activities in South Africa, they get to enjoy, they get to be taxed in one jurisdiction rather than in both jurisdictions, and that makes it easy for them to be able to do business. Bilateral investment treaties, such as the one concluded between Australia and Egypt, are also intended to provide for legal protection for foreign investment. And they provide for various standards, and which we cannot engage in this lecture. So, for example, they say national treatment. National treatment under a bilateral investment treaty means that you should treat domestic businesses, you should treat foreign investors the same way that you treat for domestic businesses. And that is to say, place foreign businesses and domestic businesses at the same level of protection, which means no discrimination between domestic businesses and foreign investors. That will mean that, for example, between Egypt and Australia, which have a bilateral investment treaty, when Egyptians are doing business in Australia, then they've got to be placed at the same level with Australians doing similar business. If Australian businesses go to Egypt to do business, they must be placed on the same level of treatment as domestic businesses in Egypt. And that can really be an important aspect of promoting economic agency of individuals. But as I said, we have very limited international economic treaties between Australia and African countries. And the implication is that there is limited international legal protection for Australian business, Africans in Australia. Can we go to the next slide? But an important aspect of the Australian international economic treaties is the membership of Australia with the World Trade Organization. And many African countries, in fact, are also members of the World Trade Organization. Now, an important aspect of the World Trade Organization regime for Australian African trade is market access for goods. And market access for goods within the World Trade Organization is about conditions and tariff and non-tariff measures that the members have agreed to regarding the entry of goods in the member states of the World Trade Organization. And each member has a tariff commitment for goods that are contained in relevant sections of the various agreements. And they agree either to eliminate or to reduce tariffs to allow the flow of goods and services across member countries of the World Trade Organization. Now, in the case of Australia, Australia has a tariff preferences system for imports from the least developed countries and developing countries. And the Australian system of tariff preferences also provides duty-free, quota-free market access to goods for goods from developing countries in Africa. So this is an important aspect of international economic law that is intended to promote the flow of goods between Australia and Africa, which African countries will have to take advantage of. I think currently African countries are not taking particular advantage of their legal rights available under the World Trade Organization in terms of their engagement with the Australia. Okay, can we go to the next slide? I think I've made the point here, so we can go to. All right, so that gives us a picture of international economic law and how it can facilitate or impede trade between Australia and Africa, and therefore in terms of how it can impede or promote economic agency. In particular, we are saying that there is very limited, Australia and Africa do not have a lot of international economic treaties. They are just the few that I have referred to. And so only Africans from countries with which Australia has concluded this agreement really get to enjoy some measure of international economic law protection. The World Trade Organization, each African member that is a member of the World Trade Organization, if you are from that country, then you also have the advantage of seeking protection under the World Trade Organization regime. So international economic law is an important aspect of economic agency, and there is a need to improve that aspect to facilitate business between Australia and Africa. Now, the next section, it looks at domestic law and how Australian domestic law and as an instrument for economic agency of Africans in Australia. And as you know, everybody probably knows that in Australia, you are entitled to set up a business irrespective of your country of original your country of origin. So under the Australian Corporations Act, under state legislation such as the Association Corporation Act of Western Australia, you are entitled to set up business that you want to. So again, domestic law can facilitate economic agency of Africans in Australia. But if you look at the literature, you also see that trade in goods and services between Australia and Africa is also growing. But the sector is largely dominated by small-scale enterprises that need laws that can facilitate what they do. And most of the time, this is the sector that needs improvement. In particular, the food industry we have a large number of African businesses that is engaging the food industry. But I think there are a lot of limitations when it comes to that sector, because the import of goods is regulated under the Imported Food Control Act of 1992. And that act requires the holding of food control certificate and labeling of food, and provides for various criminal offenses if you don't comply with the labeling requirements and so forth. And most people who are engaged in the industry are individuals and small-scale enterprises. And the complexity of the law in this sector will also make it difficult for individuals to be able to do business. We all, at least some of us, might be able to give practical examples where we carry certain items and then we get to the airport and you value it so much and then they collect it and then they throw it away. I know there's a colleague from Ghana who mentioned that to me. He got annoyed. And of course, you couldn't play the race card and succeed at the airport. It will not help you. So we are aware of the difficulty in being able to move goods from Africa to Australia. Now, my father was a yam farmer. And if I could literally move yams from Ghana, from my village, in fact, my family members are still farmers in the village there. So I could literally be transporting yams and run a big yam market in Australia here. But the Australian trade laws say that if you want to bring yam from our village, you must peel it and put it in a fridge. There's no fridge in my village. So in the first place, how can I put that in you even call it deep freeze or something? I cannot do that. So it means that I cannot bring food, yams, for example. I think I could open up a yam trade in Australia here and probably stop teaching. But I cannot do that because the law doesn't allow me to be able to move goods and services here. So really, in this area, Australian laws are really very limiting of trade and investment and economic agency. My economic agency is limited because the law doesn't allow me. And of course, you might say you want to protect the Australian populations from, all forms of, bringing in food items that can be a source of health issue, safety, and those ones. But I think that if I consume the same yam in my village, I should be able to consume it here without having problems. Can we go to the next slide? So again, another area that needs to be addressed to get Africans to be able to really engage with the Australian economy has to do with the visa system and the employment laws entering into certain professions and so forth. Now, temporary visa holders in Australia are resident for tax purposes, but they are actually foreign for purposes of doing business in certain sectors under, for example, the Foreign Acquisitions and Takeovers Act of 1975. So if you want to invest in agricultural land in Australia, or even in commercial land or national security land, you really have difficulty going there. And in fact, recently I was listening to Peter Dutton and Senator Hansen of One Nation, and they were talking about limiting the entry of migrants because of the pressures on accommodation and other matters. But also they made reference to the need to limit the sectors in which foreigners can enter. So if you are a foreigner in the sense of holding a temporary visa, if you are holding a temporary visa, you are resident for tax purposes, paying tax into the Australian economy, but actually you are foreign in terms of other economic activities. That can also be very limiting of economic agency of Africans. Of course, we can say that employment laws allow you to be able to go to any employment that you want to, for example, under the Fair Work Act of 2009. So yes, laws can facilitate economic agency in terms of your employment and so forth. But the visa requirements are an important barrier to economic agency. And in particular, if we look at visa requirements in relation to their limiting effect on economic agency, we see, for example, the subclass 482, which is the temporary skills shortage visa. Now, that visa is granted in a manner that you are tied to the employer that brought you in. And when you seek to leave, let me say the employer and the job. So when you seek to leave, you must find a similar employer who has the permit to employ you. And you must get a job within 60 days. In fact, I have personally dealt with those cases. And I have somebody in mind who I know. In the next few days, I don't know what is going to happen to his life in Australia here. So if you tie the employer to the job, to the employer, really you are limiting their economic agency. You are limiting their capacity. But also, there are also conditions as to the entry into certain professions that place unnecessary and unreasonable limitations on the economic agency of Africans in Australia. And here, I'm talking about the condition for entering into professions. So, for example, if you want to enter into the legal profession, it doesn't matter that you were admitted to practice in your home country. And I have a personal example again. I came here, I was admitted as a lawyer back in Ghana. And then I came here and I wanted to be I'm already a lawyer, but I couldn't call myself a lawyer because if you call yourself a lawyer, the Legal Practice Board will fine you for presenting yourself. So you are really a lawyer and you are not a lawyer. So now I went to the Legal Practice Board to assess my qualifications so that I can get, admission here. And I was literally asked to go and complete all the core units for the first degree. So that meant that I had to go back to school and do my first degree in law in order to be able to get admission. That comes with cost, a lot of cost involved. And that takes time. It took me 3 years. Of course, I was doing my job full time and my job supported me. But otherwise, I don't know where I would have had the money to be able to go back to school from do my first degree and so forth. This is a serious limitation in terms of economic agency of Africans in Australia. But also related to that is the visa requirements, as I said. Now, I am aware of many people in the system who finish nursing degrees, 3 years nursing degrees in Australia, and then they are told to go and do an English language test. Now, it is a serious matter that somebody who spends 3 years of a nursing education in Australia is told that, well, we will take your qualification, but we are going to extract your English language qualification from that qualification such that you need to satisfy us further of your qualification in terms of English. Again, I call these ones artificial barriers to economic agency. In fact, I've published in that area. If you can email me and I'll send you my publications relating to English language requirement. So these are important areas where Australia needs to look at in order to ensure that people's economic agency are really, seriously addressed. Now, I was looking at, again, in area of the English language and the legal profession, for example. If you finish your law degree here and you didn't have your primary school here, that doesn't satisfy the English language requirement. The only exemption that you are entitled to in Western Australia is that you should have lived in Australia or one of those predominant native English countries for a combined period of 10 years. And the qualification that you are relying on for admission should also have been obtained from one of those countries. That was how I qualified for an exemption because I was traveling all over the world. But otherwise, I would have had to sit for an English language test, even though I obtained a law degree from here. So there are serious concerns around the law and regulation of visas, in particular, employment, entry into professions, and economic agency of Africans in Australia. Can we go to the next slides? So I have some proposals that I would like to make by way of conclusion. That in order to deal with the constraining effects of the law and policy on economic agency of Africans in Australia, Australia should conclude more international economic treaties with Africans. And as I said, they are virtually non-existent, which means that Australia and trade and investment between Africa is, apart from the mining sector, is not given any serious attention at all. So we need to consider the conclusion of these international economic treaties, if really they do provide the needed legal protection. But there is also the need to simplify and make readily accessible legislation dealing with the import of goods and services to Australia. And this is necessary to increase trade between Australia and Africa. And the small enterprises that are engaged in trade in Australia and bring their goods from Africa, I think, have a lot of difficulty being able to bring their goods. And there's the need to simplify and make laws more friendly to those businesses. There is also the need to give recognition to educational and professional qualifications from African countries. There's no reason whatsoever to place limitations on somebody who comes from an English-speaking African country with the requisite qualification. It doesn't help Australia. It doesn't help those migrants. Of course, you always want to satisfy yourself about somebody's skills and all of that. So there may be some checks here and there, but essentially failing to give recognition to educational qualifications really limits individuals in terms of what they can do. And then I also propose that there must be no discrimination between temporary residents and citizens and permanent residents. Everybody who is in Australia and is contributing to the Australian economy ought to be given a fair, they say what, a fair go? Is that what they call it? You have to give them equality of treatment. And this is important. Remember, I said, I made reference to what we call national treatment, where if you sign an international agreement and a foreign investor comes in, then you place the foreign investor at the same level as what? Domestic investors. I think there should be a similar thing in terms of protecting human beings who walk in here or walk into Africa to do business. Let's provide equality of treatment. And that if you are a taxpayer and contribution, then your visa status or your citizen status should not be an overriding consideration in terms of differential treatment. And then artificial barriers to economic agency must be removed. For example, individuals should not be tied to certain employers. Okay, they should be given flexibility in terms of being able to move around employers as circumstances demand. And then I am suggesting that African countries, and I've been thinking about this proposal, so maybe it's the most important for me. African countries must conclude international immigration or migration agreements with Australia and other countries. Africa is a huge source of human capital to Australia and other countries. And we must not leave Africans to travel there and say, well, yeah, you can go and see greener pastures. The grass is not always green, as you know. But more importantly, we need those agreements to ensure that this supply of labor from Africa. If you go into the mining sector, for example, you will find a huge number of Africans in Australia who were trained in Africa and have the skills, and they are working here. Okay, so Africa should jealously preserve its human resource that is badly needed in Australia and other countries. And you cannot do that by leaving migration regulation to domestic law. You have to use international migration agreement to protect your resource. I think I will conclude here, and then I will respond to any questions that you have. Thank you.